Welcome to what you really want to know about the Doyle Memo on prosecutorial discretion, which I will explain what that means shortly. Before I get to that, don't forget to like us and follow us on Facebook and YouTube and Instagram, wherever you are watching. And if you find this video helpful or know somebody who does, please make sure to hit that share button so that they can watch this as well. So we've been getting a lot of inquiries about this new memo that came out. So I want to explain it so that everyone knows, and that if you're out there and that you think, hey, this might apply to me and maybe I can do something with my case, our contact information on YouTube and Facebook scrolling along the bottom of our screen. On Instagram, if you go to our profile page, contact page, whatever, our contact information is there as well, and you can always send me a message. So before I get to what the memo is, let's just quickly go over what prosecutorial discretion is. Prosecutorial discretion is what the government, when the government basically says that they can decide whether or not they want to try to deport you in this context, in immigration court. If they want to deport you, if they want to put you in deportation proceedings to begin with, if they want to stop your deportation proceedings, like dismiss them, if they want to reopen them, if you already have an order of removal or deportation. It refers to a broad range of different actions that the government can take against you or not take against you. And basically, they don't have to do anything, but they can. So prosecutorial discretion, when we're talking about it here with removal proceedings, we're talking about whether we can specifically, and this is what we'll get into with the memo, about reopening cases and dismissing cases. There are a few other things in the memo I want to talk about as well. I want to kind of give a brief overview of the whole thing so you can fully understand everything. But essentially, that's what we're focusing on: dismissing cases, reopening cases. So the first thing that this memo talks about is it kind of reiterates enforcement priorities that were outlined in a previous memo. So the previous memo that was issued like in September of 2021 is still partially in effect, or it's still in effect. This kind of just elaborates a little bit more and directs DHS a little bit more, because right now we have, I think it's about 1.5 million cases pending in the US in the immigration courts. This includes cases that are open and cases that are administratively closed. So that means 1.5 million people are here without lawful immigration status, waiting to see the immigration judge or sitting in an admin closure, and their cases are kind of in limbo. So this is meant to address that humongous backlog, and hopefully for people who are eligible for relief, this will help you get that relief from removal. And for people who need to see the judge, you'll get to see the judge faster. That is the goal here. So in terms of enforcement priorities, it outlines 3 different things that would make you a priority. And again, this is just repetitive, so I'm going to go through it pretty quickly. Threats to national security, threats to public safety, threats to border security. Now, with border security, they're referring to anyone who entered unlawfully on or after November 1st, 2020. So it could be you were caught at the border, that you weren't caught at the border but caught after, or it can even mean you never got caught, and then now you're applying for something and they're like, wait a second, you entered after 2020. So that's who the border security refers to. It actually goes, national security is highest, public safety, border security. And national security usually deals with terrorism. Public safety would be, generally speaking, if you've been convicted of a crime. It could also mean your involvement with a criminal organization. But essentially, those are the 3 categories for priority cases. So it discusses as well, not just that you have these priority categories, but that there are certain aggravating and mitigating factors that DHS should look at when deciding, does a person fall into one of these categories? Again, I'm not going to go into all of those now. To give you an idea of what I mean, an aggravating factor would mean committing a crime with a gun, or a really violent crime. Crimes involving children would be aggravating. Types of mitigating factor, it doesn't have to be a criminal to be aggravating. It could be multiple arrests or something. Mitigating factors can be a crime you committed was when you were young, or it could be your long ties to the US, or you're married to a US citizen. There's examples given in the memo, but they're a non-exhaustive list. Again, if you have questions about this, please feel free to contact me after this, because I am going through some of this a little quick because I want to get to the more juicy stuff here. Then it talks about how they're going to handle priority versus non-priority cases. And essentially this memo says if it's a non-priority case, you should really look to dismiss it or consider other forms of relief. Now, when I represent somebody in removal proceedings, even if I want to just have your case dismissed, DHS has to agree with me. However, DHS, because they are the ones with the discretion, and the prosecutors, they can actually decide unilaterally to dismiss your case. In other words, they don't necessarily need your consent. And I'll talk about that in a little bit more in a minute. Now, somebody on Facebook asked how to get a green card after entering the U.S. without inspection. So somebody's asking about how to get a green card in the U.S. if they enter the country without inspection. Aaron is listening and just said a time machine. The answer is, I'm not talking about that right now. I do have videos on that, and I direct you to look at our waiver videos. But right now, I really want to focus on this memo. I'm happy to answer questions about the memo, but if you do have a question about yourself specifically, please feel free to contact me privately, and we can see if you are eligible for relief in that respect. So back to the priority versus non-priority. The purpose, again, remove cases from the docket, and really, especially for people who have relief available through USCIS or something. Take it off the docket, focus our enforcement resources on our priorities. That's what they're looking at here. Next, they talk about non-issuance of an NTA. An NTA is the notice to appear. It's a charging document. It's the first document you receive that tells you you are in immigration court. It is similar in criminal court to like an indictment. It basically says you're in the country illegally. This is where you're from. You're not a US citizen or national of the US. Here's how you entered the US. And this is when you entered and where. And this is why you're not here legally. That's the initial document that you get. And importantly, DHS also have, and not just DHS, USCIS, CBP, all have the authority from the law to whether or not they want to put you in court to begin with. So you could be here illegally and never see an immigration judge ever. For your whole life, you might get lucky and nobody ever realizes it, right? Or overstay your visa, nobody ever realizes it. And basically now the government is saying, we don't want to just keep throwing everyone into these court proceedings and increasing the backlog even more. A lot of times, like if your case gets denied, you apply for a benefit, you might get put into removal proceedings if you're out of status. And what this is now saying is, if this is a non-priority, let's not even issue the notice to appear to begin with. It instructs DHS to find for cases at the earliest point. So before an NTA is issued, after an NTA is issued, whatever the case may be, the earliest possible point that they could do something to get the case off the docket is the goal here. Now, the stuff I think more of you will be interested in. Dismissal. How do we get our case dismissed? So, interestingly here, we have a difference between represented respondents, meaning you have an attorney, and people who don't have an attorney. Apparently the reason for the difference is they don't want extensive litigation, which again is the overall goal. But basically, if you don't have an attorney, they're saying, we're going to let you know we're trying to dismiss your case. And if you don't reach out, if you don't respond, then we're going to file a written motion. And we're also going to give you a continuance so you can get an attorney to find out should you have your case dismissed or not. If you have an attorney, on the other hand, they're still supposed to seek your consent to dismiss it. But anyone watching out there who may have had their case dismissed and their attorney said, I didn't file anything, that may very well be the case. I've heard of that happening a lot. To my knowledge, it hasn't happened to any of our clients yet, but DHS has dismissed cases without the other party consent. And and sometimes that is not ideal, because, and you will know in your individual situation if that's what you want to do. But if you're, for example, applying for cancellation removal, you can't get cancellation removal if you're not in removal proceedings. So it doesn't benefit you to dismiss your case, but you might not be able to stop it. Now, that is not a reason not to have an attorney, because it is always better to have an attorney, because your attorney can do something about that if that happens. Basically, if you have a strong case and they dismiss it, we're going to go to them and say, put this case back on, agree to the case. Then we don't need a trial. Just stipulate, which is, I'm going to get to stipulating in a second as well. So there is that weird difference, in my opinion, weird, because the law does technically say they don't need your consent at all. I guess that's the answer. And they're just making sure unrepresented litigants get the same or get some sort of due process in that respect. But it is a strange difference. And it is important, because if you want your case dismissed, you want to make sure that you're a non-priority as well. And what's also interesting about what they said here is that even if your case is on appeal at the Board of Immigration Appeals, whether you appealed it or the Board of Immigration or the DHS appealed it because they lost, they're also supposed to be looking at those cases to dismiss. So I actually have a few clients I need to talk to about this to see if they want us to contact DHS and say, hey, maybe this will get dismissed. It's not going to give you immigration status necessarily if you get dismissed, and that's important to keep in mind, but it will keep you in the country. And if you get dismissed, you might not have a working permit, which is another thing. If you need that, is important to talk to an attorney about before agreeing to anything. So if you are unrepresented, DHS says we want to dismiss your case, I do recommend contacting an attorney to decide if that's the right thing to do. It next talks about administrative closure. Now, administrative closure is like a pause on your proceedings. It means you have no future court date, but you're still in court proceedings. So I always explain to my clients, if you were to leave the US, you're actually deporting yourself because you're still in deportation proceedings. So don't leave. Administrative closure can be ideal in some circumstances because it allows you to renew your work permit. So if you applied, for example, for asylum, and you've been waiting to see the judge, and then your case gets closed, you've been renewing your work permit, you can continue. Your case gets dismissed, you no longer have any relief pending, so you don't have a work permit to base it on. That is a big difference for people. Now, the memo says dismissal is preferred because, again, they're not trying to help illegal immigrants work legally. They're trying to clear the case docket, which is a very big difference. Because a lot of times we do seek admin closure over that, but that they're going to be looking to dismiss cases. So they're saying we're only going to do administrative closure if we need to pause it. Why would we need to pause a case? Well, sometimes there's all different reasons, but one reason may be like a medical reason. Somebody's medically unfit to go forward with their case right now. They're not exactly sure when they're going to be okay. So say, okay, pause it, and then file a motion to recalendar when you're ready. The next thing it talks about stipulations to issues and relief. Basically, and again, this was in the last memo, but they're kind of pushing this a little bit more, saying to DHS, narrow the issues so the trials are shorter. And if someone's clearly eligible for relief and warrants a favorable exercise of discretion, then don't make them go to trial, just agree to it. And they say that if it's mandatory relief, meaning, so a mandatory relief is something where if you prove your eligibility, even if you're the worst person, if you're eligible, they can't deny your claim. They have to grant you the relief. So the Convention Against Torture, withholding of removal under the Convention Against Torture, CAT, as it's known, is a type of mandatory relief. So if you prove, and it's a very high bar, that it's more likely than not, if you're returned to your country, you're going to be tortured, then even aggravated felons can have their CAT claims granted. It can't be denied. That form of relief doesn't lead to a green card, notably, but they're saying even if this person's a terrorist or a threat to national security, if they're eligible for CAT, don't put them through the trial, just grant it. So that's something new too. It then goes on to talk about continuances. Basically, very quickly here, they're just saying, we don't want to keep continuing cases. It's not helpful. It takes up docket space. Unless there's good cause, don't continue it. Look for other avenues of prosecutorial discretion, such as dismissal. Kind of talked about appeals again already, sorry. So again, they're looking at dismissing cases and a focus on priority cases, which involve those enforcement priorities I mentioned earlier, and non-priorities if they've decided to appeal or dismiss, or if you've appealed and you're a non-priority, they're telling DHS they don't always submit an opposition, but they usually do. They're saying don't even bother. You can just not do it. And finally, and what I think besides the dismissal, what most people watching this are going to be looking out for is about joint motions to reopen and or dismiss. Now, this refers to people who already have a removal or a deportation order and are want to know, can you reopen my case? The reason that they are now looking at doing this is they want to allow non-citizens who are eligible for permanent or temporary relief outside of court to be able to get that relief. Or if you're eligible for relief inside court, but you previously weren't, so sometimes maybe you had an order of removal because you didn't have a path to legal status and you were here illegally. Now you're married to a U.S. citizen, you have an approved I-130, you now both actually in and outside the court, possibly depending on the rest of the facts, will be able to have your case reopened and or dismissed so that either you can adjust your status with the court or with USCIS. In order to get your case reopened or dismissed in this way, so these are joint motions that you're filing along with DHS, you're both signing on to. You have to show you're qualified for the relief sought. So what does that mean? If you're trying to get a green card, you have to show, look, I got the approved visa petition. I still have the relationship. I don't have any inadmissibilities. If I needed a waiver, I have an approved waiver. Whatever the case may be, you have to actually show all of this. And then you also have to warrant a favorable exercise of discretion. Again, this is for anything, most of this relief is discretionary. So what that really means in this context is if you have a criminal record, unless it's something minor, there's less of a chance they're going to agree. If you've committed immigration fraud, they're probably not going to agree. And then, of course, if you fall into those priority categories, they're not going to agree. What our plan is to do for these cases for our clients who want to attempt to reopen their cases is, number one, get the underlying, like if there is an underlying petition necessary, like a marriage petition, get that approved, and then show DHS, here's the green card application, here's their proof of eligibility, and look, they're a great human being. Please reopen, dismiss their case. That that's the way we're going to be approaching it in our office. And I think that's the best way, because you need to be able to show eligibility. Now, everything I'm saying, DHS can look through cases and decide. They're actually encouraged to even go back and look through cases and say, okay, we should reopen and dismiss this case. I don't know how likely it is they're going to do that for cases with removal orders already, unless you're requesting it. But they are supposed to dismiss cases that are already that are still in court without being requested. But again, we're still requesting those for our clients because there's no guarantee they'll come across your case. There's, again, 1.5 million cases like these that they have to look at. And then you have all these people with orders of removal that haven't been executed. So people who were ordered removed, but still in the US. So if you're one of those people and you think, hey, that sounds like now I can get my case reopened, that's who you're the person who should give us a call. And again, Instagram, go to our, private message me or go to our bio page to find our contact information, YouTube, Facebook, scrolling along the bottom of your screen. If reopening and dismissal will restore a non-citizen to permanent resident status and you're not an enforcement priority, that is one thing DHS said, that they should join the motions. Not that they can, they should. So that's a push in that direction. There aren't going to be too many people in this category because that means you were a permanent resident and then you were ordered removed. And it usually has to do with criminal history. So it depends on what that criminal history is. And the other important thing to note here is if you fought your case and lost and you have no new relief that you're eligible for inside court, and there's nothing you're eligible for outside court, they're not going to reopen your case to let you try again. They're not, in other words, they're not going to relitigate your case. The whole purpose here is to decrease the amount of cases in court, not to increase. So it is very important, if you're thinking, oh, let me just send a request to DHS, you want to do it the right way. Contact a lawyer, contact us, make sure you're eligible, make sure you're a good candidate, and then we file it, because these aren't minor filings. In some cases, it's just a request, dismiss the case. But it's good. Those are the easier ones. The ones who have removal orders already, we're going to have to show your eligibility and that you're a person of good moral character. Or I don't believe they're going to really reopen it in that regard, because it's kind of like you had your day in court, you should have left the country, you didn't, and now you're asking them to reopen your case. So this is great news for everybody that is in that position, because this is the first time, we were told that they would consider doing this before, but they were definitely giving people a hard time in a lot of certain situations, and now they are finally starting to really decrease that caseload. So hopefully a lot of my clients who are waiting for court dates that have to see the immigration judge will get to see the immigration judge sooner rather than later. So I went through a lot here. This memo is very promising for all our clients who are hoping that, look, I have a path to legal status. Why am I in immigration court? It's very positive. I know that since this has come out, it's been about a month or so, that DHS has been a lot more responsive to my prosecutorial discretion requests, kind of like that, very quickly. And they are dismissing cases. I've gotten the cases reopened and dismissed much easier than I have before this memo came out. So if you have a case that you think may be eligible for dismissal, reopening, closure, continuance, whatever the case may be, contact us today. The sooner you contact us, the sooner we can get things going and we can get you out of court proceedings, or get your court proceedings back open so that you can get some relief from removal and hopefully legal status in the US. And if you do need us, again, Facebook, YouTube, contact information, scrolling across the bottom of your screen, Instagram, go to our bio page. It's all there. Send us a message. that is all today for what you really want to know. Thank you all for watching and have a great day.